Good afternoon, and welcome to our campus conversation. This is the fourth in a series of 6 conversations over the course of this academic year. Today's panel discussion, What's Going On and Why, a first look at the Trump administration, immigration, and constitutional law, will be followed next Wednesday, February 8th at noon, by an open forum on the same issues also held here in Student Center East. Next month, on March 7th, our campus conversation will feature Professor Susan Herman, President of the American Civil Liberties Union, and she will talk about criminal justice. Today, we have with us 3 distinguished faculty from 2 Chicago law schools. I'm going to give you just the very basics of their bios in order to save time, so please understand that I am leaving out multiple awards, recognitions, books, articles, and so forth. Daniel B. Rodriguez, all the way on the far end from me, is the Dean and Harold Washington Professor of Law at Northwestern University Pritzker School of Law. Dean Rodriguez received his law degree with honors from Harvard Law School and his undergraduate degree from California State University, Long Beach. Dean Rodriguez's principal academic work is in the areas of administrative law, local government law, statutory interpretation, state constitutional law, and the law-business technology interface. He was also a professor of mine at Berkeley. Erin Delaney is an associate professor of law at Northwestern Pritzker School of Law with a courtesy appointment in the political science department there. She teaches and writes about immigration law, constitutional design, and comparative and U.S. constitutional law. Prior to her position at Northwestern, Professor Delaney served as a law clerk to Associate Justice David H. Souter of the Supreme Court of the United States and to Judge Guido Calabresi of the U.S. Court of Appeals for the Second Circuit. She received her undergraduate degree from Harvard, her doctorate from Cambridge University, and her law degree from NYU. Tom Ginsberg, closest to me, is the Leo Spitz Professor of International Law at the University of Chicago Law School, where he also holds an appointment in the Political Science Department. He holds BA, JD, and PhD degrees from the University of California at Berkeley. He currently co-directs the Comparative Constitutions Project, an NSF-funded dataset cataloging the world's constitutions since 1789. He's written several books, one of which won the Best Book Award from the Comparative Democratization section of the American Political Science Association. I am delighted to welcome this esteemed panel of legal scholars to UIC, especially at this particular moment in the history of our country. The panel will talk for about 40 minutes, and then we will take a few questions from the audience. The goal of this panel discussion is to provide legal context and insight into immigration and constitutional issues as a new president begins his term. The panelists are not here to provide legal advice to individuals or to groups, and they will not do so. Thank you.
Well, thank you, Susan, for having us here. It's a real honor, and thank you, Chancellor, for welcoming us to UIC, and thanks to all of you for coming. One of the silver linings of the various clouds of the last couple of weeks is that a lot of people are out and a lot of people are paying attention to American democracy and American constitutional democracy. And as scholars of that, that gives us some hope, even if the day-to-day is often very frustrating and challenging. The way we're going to do this is we're going to sort of proceed from the more general to the more specific. And in particular, I'm a scholar of comparative democracy and comparative dictatorship around the world. I study the legal construction of democracy and dictatorship and its constitutional basis. And so I've done a lot of thinking about democratic transitions and authoritarian transitions. And specifically, I want to talk a little bit about an article I've just written called How to Lose a Constitutional Democracy, and try to provide you some framework, I guess, for thinking about the big structural forces at work. I'm not going to talk about the details of immigration or the Supreme Court. My colleagues will do that. So we will move from the more general to the more specific. Now, in thinking about how constitutional democracies survive, right, there is a lot of comparative evidence. There are Constitutional democracies, however you define them, are a minority of regimes in history. There aren't very many of them. They tend to be stable, but they're not always stable. And one of the phenomena that we've been learning about in recent decades is democracies that seem to be pretty stable, backsliding into dictatorship, or, and I think this is perhaps the bigger risk here in the United States, just degrading in terms of their quality. The Economist Intelligence Unit just recently downgraded America from being a sort of full democracy to a flawed democracy. They have a complex rating system by which they do this, so it's hard to say exactly what triggered the precise shift. But the point is that democracy can't be taken for granted. It doesn't just stay around once you create it. It requires constant reinvigoration. And there are certainly some worrying signs. When we look at the factors that are associated with democratic backsliding or transitions to authoritarianism, we see some factors in the United States which seem to be like many of those things. One common trigger, of course, is a great financial crisis. Another is income inequality, which is very severe in the United States and has received a lot of attention. And perhaps most crucially, the public support for democracy as a system of government. I was looking at a poll which said that nowadays 1 in 6 Americans believe that it would be good or very good for the army to rule. That is, that democracy doesn't have robust popular support. This is up significantly from earlier years. At the same time that Americans' knowledge of the Constitution is not really great. Something like 1 in 3 Americans, only 1 in 3 Americans, can name all 3 branches of the federal government. And that seems to be declining as well. So this kind of combination of lack of awareness and lack of motivation to even gather information or really to consider constitutional democracy as the only game in town is certainly worrying when one looks at the comparative experience around the world. Now, in our paper, what we do is we define democracy. And we define it rather narrowly, in some sense, you might say. I mean, political scientists who look at democracy try to reduce it to the minimum possible core, which is essentially elections after which the loser concedes. That's basically what it comes down to. But one point we make is that even that requires a lot more institutional infrastructure than just simply an electoral administration, right? You have to have rights to free speech and association. You have to have, some neutral adjudicator when electoral disputes arise. And so the rule of law and at least some core of constitutional rights are absolutely necessary for democracy, however one would concede it. And so it's a relatively, it's thicker than just elections, our conception of it. Though I will say that there's nothing in that definition which requires any particular immigration policy, any particular, policy of redistribution. Those are separate sort of concepts. And democracy, just qua democracy, is really about the institutional structures that allow for turnover in power, peaceful turnover in power. And that does require a kind of legal basis. When one looks at the various countries which have seen democratic backsliding, and I could mention Eastern Europe and Poland and Hungary, where majorities that win power in one election try to rig the system so that they'll never ever lose again. In Turkey, we've seen massive attacks on civil society and the neutral bureaucracy. Venezuela was a democracy for several decades until it was degraded rather significantly in the last couple of decades, and so on and so forth. There are many such cases. When one sort of tries to step back and sees what they have in common, one thing one can do is look at strategies. What does one do if one is Hugo Chavez or Erdogan, and you really do want to take power and keep it forever? What do you do? Well, and really, I suppose the question for us is, does the U.S. Constitution do anything to protect us from those kind of moves that have been made and are potentially going to be made? And I suppose I'm going to talk about the mechanisms and then I'll talk about the U.S. Constitution, but the punchline is not very much. The U.S. Constitution doesn't really do very much. It's a really old document. Obviously, it's from 1789. If one is writing a constitution today, as many, many countries do, then one is likely to include a much thicker set of checks against authoritarian backsliding. The language, the concerns of the framers were so different from the way modern government works, that in fact our conclusion is that the Constitution, qua Constitution, doesn't do a lot to protect us. It's democracy that has to protect us from its own backsliding. All right, so what if you were a potential dictator who wanted to take power? What would you do? Well, looking at this comparative evidence, one thing, the most obvious thing, which captures a lot of public attention, is to try to manipulate electoral rules so that you can stay in power. Getting rid of term limits, something that everyone tries to do when they can, and constitutional amendments around the world that try to get rid of term limits succeed with a surprising rate. In one study I did, we showed that of those leaders who would normally by law be required to step down, in all countries, roughly 1 in 4 tries to extend their term. So it's very common to try to extend your term, and they have about an 80% batting average, highly successful. And so that's certainly a big red flag, and it'd be fairly obvious, I think, in the United States if that were to happen. But there are other things that can be done that are much more subtle. One is to obviously attack the independent checks on power. The judiciary, the federal judiciary in our case, Congress, to try to degrade their ability to gather information and to rule against a powerful executive, centralizing the executive power and undoing civil service rules, for example, which I expect we're likely to see many such attacks in coming months. Centralizing power within the executive branch away from bureaucratic agents who, after all, are neutral and meritocratically selected. Of course, that means that they're independent, and that's something that is certainly something to watch and to mobilize around. Degrading the public sphere is a major strategy. So when one looks at Eastern Europe or Turkey or Sri Lanka or many of the other countries which have undergone this democratic backsliding, one sees efforts to attack the media, to undermine essentially the epistemic basis of democracy. If there are no facts, then we can't debate policy, right? Policy is just a matter of opinion, whereas what democracy in its paradigm form requires is that we agree on the facts, and then we can debate which is the best way to address the problems, right? We can maybe have different orderings of which problems are the most severe. Well, those are things in which political systems, democratic political systems, allow a lot of disagreement and facilitate that kind of disagreement. But if there's no common epistemic basis, if there is not neutral information being produced by government agencies and being released to the public, if there is not a neutral public sphere in which the media can thrive, then it's very easy to manipulate the information the public gets, obviously, and there's no more room for policy debate. Another fairly common tactic, and it's fairly straightforward, of course, is manipulating elections to eliminate political competition. We are seeing now in the United States, and this has been widely commented on by electoral scholars, by constitutional scholars, but the idea, of course, that the drawing of district lines, that elections are run by state legislatures which are themselves partisan, is not common in comparative experience. Most democracies have neutral election commissions which will draw the lines and police and run the elections. We don't do it that way in this country. And of course, the obvious risk is that whichever party's in power is going to try to draw the lines and rig the state election so they never lose, and that's what we have. A particularly egregious case, I think, happened in North Carolina after the election, after the governorship changed in a very, very close election this last cycle. You may have seen this in the news, but what's significant to me is this is exactly the same tactic that Hugo Chavez used in Venezuela. When his party lost the election, the mayoralty of the city of Caracas, before the new person could come into power, before the opposition person could take office, they decided to take all the power from the city of Caracas and create a new federal district which had all the effective power to run things, and in which the president appointed the head of that federal district. And as famously noted, in North Carolina, what they've done is essentially say that the governor has lost a lot of power between the time the governor took over, or the governor was recognized as having won the election, and the time the outgoing legislature ceased to operate. They reduced the appointment powers of the governor and set up, in particular, a particularly significant one in this regard, is setting up a state elections board which, although it used to be majority appointed by the governor, now would be evenly split between the two parties. Democrats one year, Republicans the alternating year. And it just happened to be the case that the Republicans would, the only time they ever had elections, or the only time elections are ever scheduled, are when the Republicans are chairing the state election board. Well, that's not really, a fair or neutral way of policing elections in any country. And so we do see some signs. Can the Constitution protect us? Well, our Constitution does have a lot of checks and balances, but they assume a kind of separation of parties, as one famous legal article has said. Separation of parties, not separation of powers. That the parties are what check each other. And when you have unified government, one party can do a lot. There's not a lot of structural checks if one party controls, for example, all three branches of American government. That's what politics are about in those periods. And we had an earlier one in the New Deal, and that also, I think, critics of the New Deal argued that that was a democratic retrogression, and it's an interesting comparison. But in the earlier period, what made all the difference was politics in the Democratic Party. And the marginal member of Congress, the median member of Congress, if that person thinks that they have more to win by, abandoning constitutional principles and going with their partisan interests, well, then the party is really, really running the country. And all the things that we think of or take for granted are at some risk. If that person thinks, on the other hand, that they're likely to lose elections if they are too partisan, then there's an effective check on the presidency and democracy can continue to function. The point is that it's all quite contingent on whoever that median member of Congress is when you have one-party government. And I have no idea who that is here in the United States right now, but it's certainly a Republican. And that, of course, calls for those of you who are concerned about the state of American democracy to be very active in terms of calling the representatives. They particularly here in Illinois, where we are a split state. We're not a one-party state. Let me just say one other word and then I'll turn it over, which is, parts of the Constitution may not only not protect us, but they might actually facilitate certain bad developments. And here I think of the First Amendment. The First Amendment as, a jewel in the crown of American constitutional democracy and allows a lot of, allows mobilization and such. It also prevents us from, policing rampantly fake news. There can be no government intervention in that. It is left up to the public sphere to police itself as to what the news what news will be listened to. And, that requires a lot of faith in the people. That's the theory of the First Amendment. But they can't work with a passive citizenry that is not engaging in active consumption of the news. Freedom of information is not constitutionalized in the United States. Judges don't do a good job with that, particularly when the national security flag is waved. Hate speech is facilitated by the First Amendment. And so, there's a lot of ways, and I could go on, but I don't want to take up all the time. There's a lot of ways in which our Constitution, though it is, a very central, sort of almost religious text, and it's something worth fighting for, it wouldn't protect us from a serious attempt at constitutional retrogression in the United States. Thanks very much.
On that light note, I want to echo Tom's thanks to UIC, to the Chancellor, to the Provost, and to all of you for being here. I'm tasked with talking about immigration. So I want to say a couple of things to start out. First of all, this is what the administrative state looks like with regards to immigration. This is painful, right? Your eyes are hurting. This is just the executive branch. So underneath the president, the Department of Homeland Security, Justice Department, Department of Labor, Department of Health and Human Services, and the State Department, all the different sub-portions of these agencies that affect immigration. This is the Immigration and Nationality Act passed by Congress. So this thing that people say is more complicated than the tax code, and this implementing organization together combine to create one of the most opaque, difficult, frustrating, and frankly, oftentimes demoralizing areas of the law. So on that, again, happy note, what do we make of what President Trump has done? What might he do in the future? What I want to talk about briefly is what he may do in the future on some of the topics that are may very well be of interest to people in this room. Also what he has done, how we might think about the executive orders that came out last week, and then maybe a call to action, how we should think about immigration law going forward. So one thing President Trump has not yet done is address DACA. So Deferred Action for Childhood Arrivals, many of you will know that was a program, it was a policy under the Obama administration that allowed certain unauthorized immigrants who arrived in the U.S. as minors, as children, to receive a renewable 2-year period of deferred action from deportation, as well as eligibility for a work permit. So USCIS, which is over here, processed those applications and those renewals up until January 16th, 2017. They're good for 2 years. What is President Trump going to do? Thus far, he has done nothing. There is an executive order in draft form that is floating around out there that he has not yet signed, which would say that he will refuse to continue the DACA program, though he would allow current work authorizations to expire on their own accord. That would, what that executive order would also do is not allow anyone with DACA status to leave to go on a school trip outside of the country. What people are saying about this as yet unsigned executive order is that it's not that draconian. It's not, it's not continuing the program, but it's not necessarily doing some of the things that he had threatened to do, including making DACA recipients a priority for removal. And so maybe if he does this, or even if he doesn't do it and just allows DACA to expire on its own accord, what he's really doing is saying, Congress, you should fix this. So people should think about, is this an area where Congress needs to take action and actually pass the DREAM Act? Could pressure force them to do that? I think the DACA recipients, the Dreamers, have historically been very politically savvy about protesting, very politically palatable to all sides, right? These are young people doing wonderful things. Many of you might actually have DACA status and be here at college. There's all sorts of wonderful things about that. There was a very powerful article in the New York Times about getting a 4.0, and that being, what you can do to show, that you're making the most of your opportunities here in the United States. So, there's some good politics behind, but it's not a rosy picture for the DACA recipients. And one of the reasons we know it's not that rosy is because of something hidden in one of Trump's executive orders last week. So a lot of the attention has been on the Protecting the Nation from Foreign Terrorist Entry executive order, which was issued last Friday and encouraged the massive protests at airports. But there were a couple of executive orders earlier last week that are also of note and that may not have gotten as much attention. One of them, on the interior, outlines new enforcement priorities for the Trump administration. All right, what does this mean, enforcement priorities? Well, if there are 12 million people here who could be removed based on our current understanding of immigration law, 12 people without authorized documentation, how do you remove all 12 million people? The Obama administration focused on those who had committed serious criminal acts. And there's a certain resource constraint. There are only 35,000 beds per night that can be used to detain people. There are only so many ICE officers, the Immigration Customs Enforcement officers. Of course, there are many of them. It is the second largest police force after the FBI, and if you take ICE and add Customs and Border Protection, it is the largest. Customs has 300 airplanes. They have more buses than Greyhound. This is a massive operation, but still not nearly funded to the amount that it would need to actually remove everyone who could be possibly removed. So the Obama administration had these priorities. Part of DACA is understanding that group of people should not be considered a priority under the Obama administration. What the Trump executive order last week did was it said that there are some new enforcement priorities. So when ICE is confronting, how do we decide, using our prosecutorial discretion, who do we pick up or who do we not pick up? Trump had some new advice, and critically, that goes beyond just people who have committed criminal offenses. Sean Spicer, our very helpful and forthcoming is a good word, said that the Trump administration would focus on criminal immigrants, but the executive order says differently. It says that anyone who has committed acts that constitute a chargeable criminal offense is someone who should be a priority of ICE. Acts that constitute a chargeable criminal offense. So you have not been charged, you have not been found guilty of a criminal offense. It's certainly not a serious criminal offense, or some of the criminal offenses in the INA that require at least a year's worth, a charge that would lead to a year's worth of jail time. This could just be a misdemeanor. So if an ICE officer thinks that you have committed acts, has reasonable suspicion that you have committed acts that constitute a chargeable criminal offense, that is someone who should be a priority for removal. What are possible chargeable criminal offenses? Misdemeanors: public intoxication, reckless driving, in some states, possession of marijuana. So this is a much more dramatic set of priorities than we saw under the Obama administration, and isn't exactly true to say it's just criminals, right? This is much broader than that. Now, the flip side is if everyone is a priority, no one is a priority. So, very hard to, if you have such sweeping understanding of priorities, it becomes hard to implement that, which may be a comfort, but some sort of assessment or sense that will know this is the way it's going to be, this severely criminal acts that are of certain severity. That's just not how it looks anymore. So another thing that the executive orders did last week is President Trump spoke very strongly against this idea of sanctuary. So I just want to say a couple of words about sanctuary cities or other kinds of sanctuaries, sanctuary campuses, churches, things like that. So there's an overarching point, which is that there's a limitation on what states have to do. The Constitution limits what the federal government can demand of states. So in this area, maybe the Constitution does do something. It may not help our democracy, but it might help democracy at the state level in some way. And the powers that the federal government has to force states to do its will, or state entities, are fairly limited. So Trump's executive order focuses on two things. One is a policy under the Immigration and Nationality Act that reinvigorates, or what he wants to do is reinvigorate relationships between state or sub-state entities and the federal government, so that the federal government could deputize local law enforcement officers to act as mini ICE agents. This happened before under the Bush administration. It happened at a lesser amount under the Obama administration. The local law enforcement officers can't order you to be removed, but they can participate in this process. They can help. This is optional. The federal government cannot force states to do this, and in fact, it says very clearly in the Immigration and Nationality Act that it has to be optional. But there will be some states that want to help. So you need to be aware of that. And there will be some sub-state entities that want to help. So in 2007, Lake County and Waukegan actually asked the Department of Homeland Security if they could be deputized. We would like to be deputized to help ICE in finding and apprehending people that are in violation of the immigration laws. So you have to be attentive to know if sub-state entities have asked to do this. So far, I wasn't able to find anything right now, and I think certainly Cook County and everything we've heard from Rahm Emanuel suggests that Chicago will not be one of those entities, but that's something to be aware of. But again, they cannot force states to do so. The second thing is that the executive order brings back secure communities, which is a Bush-era program that was altered slightly by President Obama into another form. But basically, it says when you send data to the FBI, which you have to do as a local law enforcement officer, the FBI database about people and the Department of Homeland Security database about immigrants gets merged. And so the local law enforcement officer will know if this person who's been arrested has some sort of immigration violation. What DHS can then do is it can ask local law enforcement to detain the immigrant on grounds of, or the alien. Immigrant has a specific meaning under the Immigration and Nationality Act. I'm not using it in that way. I'm just saying the foreign-born national without status, right? That person could be detained, but it's a request. You do not have to honor that request. It's clearly a please hold this person. So again, Chicago and other so-called sanctuary cities have said we will not honor these requests. At this point, there is no way for the federal government to make you. The one area where there does seem to be some action by the federal government already is in this information sharing aspect. So you have to share information. There's a part of the statute that says that the states cannot prohibit people from sharing information. So it's a prohibition on prohibition. This is part of what the Trump executive order says, that if you violate this prohibition on prohibition, well, we'll take away your federal funding. And so this has gotten a lot of attention. What does this mean, the prohibition on prohibition and federal funding? Well, first of all, it's not clear that the prohibition on prohibition has much teeth. It's just, as I think you're getting the point, a prohibition on prohibition. It doesn't say you have to actively provide information. It just says you can't prevent people from providing. It also doesn't say you have to collect information, right? So there are a number of ways to be in compliance with this law without actually doing a heck of a lot. As San Francisco has said yesterday it filed suit against the executive order on this ground, saying, by the way, we're in compliance with this. We're not prohibiting individuals from doing anything, but we're not saying they have to. So then what federal funds can be withheld? What is the stick that's being held over this? Well, the Constitution has some rules about that as well, or the court as it's interpreted the Constitution, and you can't just snatch away federal funds willy-nilly from the states. There's a set of requirements. You have to know about these conditions beforehand. The conditions have to be unambiguous. The conditions have to be related. So if you're failing to fulfill a law about information about immigration status, you can't just take away park money for the parks or something like that. It's got to be connected. So right now, the only money that seems to have been clearly conditioned in advance on fulfillment of this information sharing law is money that's connected to the State Criminal Alien Assistance Program. And right now, Cook County, at least in fiscal year 15, Cook County got $1.3 million from this, which sounds like a lot to average people, and my boss is here. It sounds a lot compared to my salary. He's just
About double.
taking notes. But it's only 0.3% of the entire Cook County budget. So this is a threat, but it doesn't seem to be one that necessarily should encourage Mayor Emanuel to capitulate, right? So that's where we stand right now on all of that. The one thing I will note about non-law enforcement sanctuary, but just sort of this idea of sanctuary status, is that, and a number of people on the left sometimes worry about false security. So one reason that some churches, campuses might say, well, we're sanctuaries, is because ICE itself has allowed that status. So let me explain what I mean. There is an ICE memorandum, I'm holding it right here, which says that it is ICE policy not to bring enforcement actions in sensitive locations unless exigent circumstances exist, so things like national security. So no arrests, no interviews, no searches, based on their own policy in schools, including schools of higher education, churches, hospitals, weddings or funerals, public demonstrations. This doesn't mean they can't. It just means they're choosing not to. So there is only a limited amount that can be done if the ICE changes that, because then you're dealing with just like, an FBI agent. There's a series of regulations about how ICE agents can ask questions, or do they need warrants, and there's a lot of detail about that. But there's nothing that with that kind of information, with an arrest warrant, that necessarily could keep an ICE agent out of any campus or even a church or a home. It follows regular kind of federal law on that. The Constitution only protects you so much once you're dealing with arrest warrants that have been properly procured. So some of this discussion about sanctuary campuses, sanctuary churches, is limited or is functioning under a regulation or a policy right now that is very important. There's no reason to think that it's going to be changed, but it is just a policy where ICE won't go in and engage possible people with unauthorized status in those places. So there's a lot more to talk about. There's a lot to talk about the impact on refugees and the ban from the 7 countries, which maybe we can talk about in Q&A. The one thing I will say, and to conclude and to pick up on Tom's points, the Constitution may or may not do much about protecting some of these areas, and but popular constitutionalism, or how you understand the Constitution to protect you, how you understand discrimination, what discrimination means about the Constitution, is very vibrant. It's had a lot of impact in other areas. And continuing to be out and protesting and explaining your understanding of what equal protection means, what does it mean to be treated equally, is valid and is extremely important. So being a norm entrepreneur, being a constitutional norm entrepreneur, there is a place for the public in that articulation of constitutional values, and staying engaged and active is very important.
Thank you. So I hope the Chancellor and the Provost will print me a quick thank you again for the opportunity to be here and to be welcomed. I was tasked to talk a little bit about the Supreme Court. I agreed to do that when I thought not much would be going on with the court, but there it happens. Before I turn to the Supreme Court and take just a few minutes before we get to questions, I just want 2 sentences, if I may, about executive orders which have been raised, obviously, in connection with this conversation, very much on all of our minds, and Aaron noted that. Just sort of constitutional law 101. Where does the president get this power? The president, not unique to President Trump, other presidents have done this, and indeed President Obama was widely criticized from the right for substantial exercise of the authority to issue executive orders in areas including immigration. It's part of the president's inherent powers, you might say, or powers granted by the Constitution to issue executive orders. It's a very broad power. It is not without limit, though. Some of these executive orders, as was the case with the Obama administration and others, will be and are being challenged in court. So presidents lose from time to time in the issuance of executive orders by virtue of the court stepping in and viewing the executive order as inconsistent with congressional statutes, with the Constitution, and the like. So another way to put that is stay tuned for the legal challenges to some of these executive orders. And the other point that is important to make, particularly in the context of the immigration orders, which have generated an enormous amount of controversy ongoing, is that Congress can step in. Doesn't mean they will, but Congress can step in and, in essence, overrule these executive orders, or, on the other extreme, instantiate these executive orders through legislative action. So, again, stay tuned is what I would say. Well, so the Supreme Court is an important player, to say the obvious, in connection with immigration and constitutional law, which is our topic. So to say a few sort of fundamentals, largely covering terrain I'm sure you know about already. The current Supreme Court is narrowly divided, or should say quite divided, politically or ideologically, between the more conservative justices and the more liberal justices as issues come up. Justice Kennedy looms very large. It's often said, in some ways, the most important public official in America, although don't say that to Donald Trump, I suppose, these days, in that he is cast often the deciding vote in a number of cases. It was almost a year ago when Justice Scalia died, leaving a vacancy in the Supreme Court. Justice Scalia being a very conservative justice on the court, and although President Obama acted quickly to nominate Merrick Garland from the D.C. Circuit, that nomination, as you know, languished until the end of the presidency, and that Obama did not have the opportunity then to make an appointment to the Supreme Court. That appointment, by any way you slice it, would have shifted the balance at least somewhat from the right to the left. Late last night, as you know, President Trump announced his appointment of Neil Gorsuch to the United States Supreme Court. What do we know about Judge Gorsuch? We know he is a judge for the past decade on the United States Court of Appeals, the second-level court in the United States, in the 10th Circuit, which is to say in the region that accompanies a number of the so-called Rocky Mountain and southwestern states, including his home state of Colorado. He has the pedigree that is not uncommon among the Supreme Court. Indeed, now, if confirmed, all of the justices would have graduated from either Yale or Harvard Law School. He is a renowned conservative, which is to say he's renowned for being conservative, and he's also renowned for, as best we can discern, for being a highly respected judge. He was on, as President Trump said last night in the announcement, the short list that then candidate Trump had announced a number of weeks ago. So the vetting and the public scrutiny of the many judges on that list, including Judge Gorsuch, had been going on for some period of time. He would, if confirmed, replace Justice Scalia, and there's much that's in the press and will be in the coming days about his connections to Justice Scalia and his association with his jurisprudence. I think I read someone call him Baby Scalia. Not the most respectful term, I suppose, to describe the justice, but you get the judge. But you get the point, which is he's seen as within the general mold, ideological and if not by temperament, with the late Justice Scalia. He is, I think, it's widely viewed as one of the more conventional choices and one of the safer choices, particularly when compared with other judges who were on President Trump's list. Now, maybe that suggests a retreat to a certain conventionalism on the part of the president, or not. I'll leave that to others to speculate. What are his chances of becoming a justice on the Supreme Court? I think it's fair to say the chances are pretty good, given the configuration of the current Senate, which is charged with the obligation of confirming justices to the Supreme Court. There are two ways in which that can happen. in the course of the confirmation process. The easiest, as it were, and my own opinion is the most likely way, is that a majority of the Senate will vote to approve Judge Gorsuch to the Supreme Court. The Republicans hold a narrow minority. If everyone voted just on partisan or votes on political party, he would win on that score. When he was appointed to the United States Court of Appeals, he was confirmed unanimously. There's a world in which one can imagine, although in recent days it may not be the world that we all live in which there would be widespread support for a judge who, by credentials, by background, by the usual standards of appointees to the Supreme Court, would be regarded as acceptable. As I mentioned, that's not the world in which we live. So there is already some indications, as beginning with the announcement and continuing on in the last 18 hours, that a number of Democratic senators will oppose, or likely to oppose, an enormous pressure. I'd say that by and large, they fall along sort of two points of view. Although that's minimizing in some sense the nuance of the opposition. One is what conservatives call sour grapes, but it is an acknowledgement of the fact that many folks throughout the United States, particularly on the left, regard this seat as having been stolen from the Democratic Party and from President Obama. Is that the obstruction of Merrick Garland was unacceptable, historic in its impact, and they're simply not going to countenance an appointment of this particular judge. One wonders what the end game is, or how long that could be stalled. But I would say that the one mechanism would be oppose, oppose, oppose. How are the Democrats going to do that, given that they're in a minority in the Senate? Well, that would largely be based on their use of the old technique of the filibuster, which in short is a long-standing rule or practice of the Senate that gives a minority of the United States Senate the ability to filibuster, to what used to be in the Mr. Smith goes to Washington days, to talk the issue to death, but in any event, in the now streamlined days, to announce that a critical mass of senators, a less than a majority, but a significant number, will not allow this appointment to go through. Up to the present, that is throughout American history, if that filibuster tactic would be used, that would be enough to stop a nominee. That is to say, in other words, if 48 Democratic senators filibustered the nomination would be done. There are nonetheless a mechanism to get around that option. One, and the most straightforward, is that a number of Democratic senators, whatever their views about the merits of Judge Gorsuch, whatever their views about the Garland nomination, will take the position that a filibuster would be unacceptable for the Republic, and would jump ship and vote along with the Republicans to confirm Judge Gorsuch. Is there any chance that would happen? You bet. As many as 8 senators, Democratic senators, are on record, not about Judge Gorsuch in particular, but on record in saying that the option of using the filibuster in order to block a nominee to the Supreme Court is unacceptable. Those 8, joining along with the 52 Republican senators, all of whom can be expected to vote for Gorsuch, add up to 60, and that is enough to break any filibuster by a minority of Democratic senators. The other option, perhaps not the most eloquent phrase invented to describe a political tactic, is what's been called the nuclear option, which has been applied in connection with lower court appointments, but has not yet been applied to Supreme Court nominees, and that is the Republicans using a procedural device to overcome the filibuster by regarding the filibuster as out of order and moving the issue of the nomination directly to a Senate vote. So those are the scenarios. I think one of those scenarios or another of those scenarios, and shows you how fast moving it is. So Erin kindly, 5 minutes before we began, looked on the internet to find that President Trump has indicated that the Republicans should use the nuclear option. I hope he was talking about the nuclear option in the Senate, but you never know. In order to overcome this. All of this is to add up to this point, and that is, it's highly likely that the Judge Gorsuch will be nominated, will be confirmed to the Supreme Court. Let me just say in closing what that means for the Supreme Court. From one perspective, not a whole heck of a lot, because he replaces a very conservative justice. It doesn't change the balance of power in the court. From another perspective, though, that appointee and potential other appointees that might be made in the coming years, Judge Ginsburg is elderly. Certainly, Justice Kennedy, there have been rumors swirling around about the possibility of him stepping down. It may well be that that will be the big fight. That is that the resignation of Justice Ginsburg or Justice Kennedy in particular, given where they are in the alignment of views on the Supreme Court, could set up an enormous amount of controversy. So depending on not only your politics, but your views as to political strategy, there is a very hard and interesting question of whether this is the nominee to fight about. I'll just say in conclusion, a number of the issues that are likely to come before the Supreme Court in the coming years are similar, not dissimilar to the number of hot-button issues that have come before the Supreme Court in recent years. Affirmative action has not been resolved once or for all before the Supreme Court. Restrictions on abortion, the scope and limits of court decisions regarding campaign financing, still some major issues involving the Second Amendment, religious liberty. All of these issues are likely to gain a lot of attention in the confirmation process. And so I'll end with immigration, which has been the topic very much on the mind. Judge Gorsuch has not written a number of, or I think any, big blockbuster immigration cases on the lower court, on the 10th Circuit, but he has given some indication, strong indication, about skepticism that he has about the scope of executive power, and skepticism in particular about the role and function and performance of administrative agencies and the bureaucracy under the federal government. That, along with some strong opinions and speeches valorizing the separation of powers, gives some comfort to those who believe that on the one hand, he's a very conservative guy, no doubt about it, but on the other, his brand of conservatism may be one that will, in the interest of protecting the separation of powers, be a check, along with his other justices, against the possible aggrandizement of power on the part of the president. So I'll stop there in the interest of time.
Thank you very much for a wonderful panel and wonderful presentations. We have a little under 10 minutes. There is a microphone in the back, so Elle will find you if you'll just raise your hand if you want to ask a question. You want to just stand up and ask it loud?
I think I need a microphone.
Okay.
And I'll try to be really quick. You're talking about how the constitutional democracy can be in danger. This isn't with scholarship behind it, it's just the impressions of the citizen. I think for the last several decades, the plutocracy has been framed a social contract to the point where now the constitutional democracy is also not functional anymore. So we've got, it's evolved to the point where you have people that are actually like, and this isn't hyperbole, using Nazi ideology and language in the White House. And their point is that they're taking everything, they're taking the assets of the American people. To the point, no Medicare, no Medicaid, no public education, on and on. In my mind, I see a comparison to what happened in Eastern Europe at the fall of communism. And I wonder what the panel thinks of this. Is that, are we at the point where we're near a revolution because there's become a breaking point that there's just nothing more for these forces to take from us, and that the only way to get the constitutional democracy back is it's not going to be through constitutional means, but it's going to be through revolution.
Here's a nice, easy question. Tom.
Yeah, well, I can't pass that to you, Dan. So, thanks for the observation. One thing that I do worry about, obviously, you have a situation now with a minority government, right? A government that did not win the plurality of votes. That's governing in a rather extreme way, and I really genuinely worry myself about significant backlash. But what your question provokes for me is, why do we see this backsliding all over the world? Why do we see constitutional democracy under pressure, even in democracies that have been very, very stable and very well established? And my own conclusion echoes yours in the sense that I think rising inequality is a huge problem, that the mobility of capital but not the mobility of labor which is our global economic system, has meant that there's a tremendous amount of the division of returns to capital and labor have skewed, and capital's winning in that, and that provides a very dangerous environment for constitutional democracy. I also frankly think that there is a global anxiety that in my view is related to the structure of the planet and this sense that there just isn't enough. And so I've got to grab as much as I can now for me and mine. And that kind of inability to conceive of a sharing economy, in some sense, has created these anxieties which play out in racism and anti-immigrant sentiment and stuff like that, but that they actually have a deeper cause.
I'll just say, again, I appreciate the comments. I don't disagree with them. I'm a little more optimistic than Tom is about the structure of our system of checks and balances and our system of federalism, which you didn't talk too much about, but is remarkable, unique in many important ways, not to be taken for granted, but does give some comfort and sustenance. Having lived most of my life in California, Texas, and Illinois, respectively, very different states, I do find some comfort in the vitality and vibrancy of local communities. It is not a panacea, and they're not purely safe spaces or sanctuary cities and states in a global sense, but it makes it at least hard to overcome and very difficult. I'll also say one of the most ominous aspects, and Tom certainly talked about this in his presentation, is the attack on the media and this business of fake news and alternative facts and all that. That is just absolutely bone-chilling because of the necessity, the imperative, given your point, of having the checks of sort of like public accountability and in the sunshine. So we have to demand our media in every form it takes to hold our public officials accountable.
Another question? Yeah, the woman in the back in black and white. Mm-hmm.
Hello? Hello?
Okay, just scream it out. Stand up, please.
It's just something I read this morning. Oh, sorry. That Gorsuch is known for his literal reading of the Constitution. I was wondering if that was something that Scalia was really known for, and how that could
2212.
influence the
22.
important decisions that they make.
Yes, he was known for exactly that, the believer that the text of the documents, the Constitution or statutes, are what matters, and context in the sense of statements of history, of the views of the framers, or in the case of statutes, the views of legislators incorporated into legislative history doesn't matter much, was a hallmark of Justice Scalia's jurisprudence, and indeed of some of the other conservative justices on the court. There's every indication, based on what Judge Gorsuch has written and what he has said publicly, that he is a strong believer in that approach to the Constitution. So yes, that matters enormously, but again, in context, it matters far less given the configuration of the court, because the seat that he is replacing is the seat of Justice Scalia.
Yes.
So I'm actually visiting from Austin, which is known as Sanctuary City. Yeah, welcome. Do that. So I would go into a tirade of swearing if I were to talk about the Supreme Court or the backside of democracy. So I'm just going to focus on this one issue relating to my city. Greg Abbott, our governor, has threatened to remove, like, the sheriff of our county, Claude Hernandez, or even Steve Mayor Adler. So I'm wondering, we talked about states or even sub-state governments, the prohibition on prohibition, all that. How much power does Greg Abbott have in removing their power of a sanctuary city? And what does that look like across the U.S. for places other than Chicago or Austin that seem to be thriving and doing quite well the way that these governments are being operated?
That's a great question, and it basically opens up this idea that there are levels within levels. So I was talking about what the federal government could demand of a state or of a locality, but localities are embedded with their own states, and local government law varies from state to state based on how the state constitution is written and how things like home rule are structured. And we happen to have on the panel an expert in local government law who also lived in Austin.
Yeah,
I'd keep it very, very brief. He has a lot of power. because the structure of local government and state government in Texas is very much redounds to the benefit of the state government. So Austin being a blue city in a red state, Austin will have a very hard time resisting that kind of encroachment. It would be different in Illinois, given the relationship between Chicago and charter cities and the state, and even more different in California, where localities have quite a lot of power vis-a-vis the states. But as Aaron said, it really depends. It's state by state.
Other question? Yes, go ahead.
Is this working? I don't want to sound like Nancy Pelosi. Another executive order last week dealt with the requirement for executive agencies to remove 2 regulations for every new regulation that they issued. That hasn't got nearly as much attention, it seems, because it got drowned out by even more horrendous executive orders later in the week. But that seems to be, at least on one level, an encroachment on the laws Congress passed, because every regulation is based on a law. And regulations are how businesses see them. Protections is how consumers should see them, because they're designed to protect consumers against something or to set the criteria for qualifying for a public program, public benefit. So is this another example of ways in which a autocratic executive could try to gain power by removing the effectiveness of laws that have already been duly passed but now no longer able to be implemented?
Yeah, well, it's a rather strange thing on its face. What it does, obviously, is it entrenches the status quo of regulation. It makes it harder to pass new regulations, obviously. But, depending on your agenda, even a right-wing government might want to pass new regulations. It does not stipulate that the 2 regulations to be removed or rescinded have the same significance as the regulation which is going to be passed. At least I didn't read it closely, but that's my understanding. And so it's really a public relations ploy in that sense. But it is obviously, so maybe that's all I'll say. It doesn't strike me as it's a particularly aggressive move. It says, I'm deregulating. I've done something to my supporters. But you're not really deregulating until you aggressively remove regulations. And the bureaucrats in the federal government, who are pretty demoralized, are not going to be pushing a lot of new things under this administration because they know they can't get much through. So it freezes the situation. Yep.
Okay, one more. It's just a little after 1 o'clock. We'll do one more question.
Yeah, hi, thanks so much for being here again. I had a specific question, particularly towards you, because you were mentioning about extension of undocumented and in relation to correlating with ICE for misdemeanors. And I wanted to ask about the trial system for that. So say, for example, if they're actually convicted of a misdemeanor, or if there's going to be some sort of correlation with ICE if there's just a charge.
It's a great question, and I think the unfortunate answer is we'll have to wait and see, right? All we know is that a new priority of the Trump administration is, as I said, to remove those aliens who have committed acts that constitute a chargeable criminal offense. So that is just acts. It has nothing to do with whether you have been in trial or anything at all connected to having been convicted of a criminal offense. It doesn't even require that you have been charged with the offense. It's just chargeable. So this is strong language. It isn't necessarily unconstitutional, right? Because these are people who are already removed. So this is just a question of what order should you seek to try to actually start deporting people that are already deportable, right? You see the fine grain, so it's hard to know how to get your hands upon it or do anything.
What about engaging in political protest?
That is exactly what you can do. And so that's why I finished my comments by saying the most important thing with some of this immigration-related stuff is engaging in protest.
No, I'm saying the opposite.
Oh,
what if engaging in political protest puts you at risk because you are now subject to a chargeable offense? Does that become a window to basically round up folks at the airport saying you're protesting?
So that's why the other ICE document that is from under the Obama administration matters so much, because this says we will not conduct enforcement actions in churches, schools,
But it's still a chargeable
or at
offense, though.
public demonstrations.
That says they won't enforce it, but it's
Right.
still a chargeable
So
offense.
if your photo was taken in an
Yeah.
ICE happen, I think it's the question about identifying whether it's a chargeable, what would have been a chargeable offense, public disruption, and then an ICE officer coming across you and having reason to believe that you had conducted those acts. That may be a little bit hard in terms of the number of people out on the street. It's more likely that it would have to be an act that you were in the process of doing in order to be, really immediately operational. That doesn't mean the terrifying and extreme possibility that you outlined couldn't exist. It could.
I want to just say 10 seconds on this before we close. People who study this area have talked, we use the term crimmigration for the immigration system. It's the merging of the immigration system, which is an administrative body of law, with criminal law, in which you're subject to really very significant sanctions, deportation, but they're not characterized as criminal. And this detention and all the machinery of criminal law is actually sitting in the administrative state. I think the answer is going to depend on how much due process judges think you ought to get within the immigration system. And because that's administrative, it's usually less than in the criminal justice system. And so that's where all the rubber's going to hit the road on
Much less, and there's a big case, there's a case before the Supreme Court right now where they're discussing that issue, and there's another case that tees it up even more clearly, a case called Castro, that is being reviewed for the court to decide whether they're going to hear it right now. And those are, Jennings and Castro are two cases that are going to put the issue of how much process is due to someone who is not an LPR, someone who's not a green card holder or not a U.S. citizen. So again, stay tuned.
Could I briefly ask what the follow-up would be on our part, seeing as how there's a lot of questions that are being asked? Protesting is obviously something that I'm advocating, that you're advocating, but there are issues that arise from that. So outside of protesting, outside from our day-to-day activities, is there any other recommendations that we can move forward with outside of just waiting?
Well, as Dan said, Congress, certainly in terms of DACA recipients, Dreamers, that is a very politically attractive group, and the DREAM Act failed, but did get some attention. I mean, there is a push. Congress can solve some of these problems by taking action. I don't know how likely it is, but that's another route.
Call your congressman every day. Get everyone out to vote in 2018.
Okay. All right. I was waiting for a slightly upbeat note on which to end, so we will end here, and please, let's thank our guests again one more time.